Okay. Welcome everyone to the eMoney experience. Welcome back to the podcast. Today we'll be talking about the new crypto regime in the UK, specifically admissions and disclosures, which was set out in CP 2541. And we'll just go over the basic rules that the FCA they are proposing. These aren't finalized as at the time of recording. So we'll first discuss the due diligence procedures that the UK qualifying crypto asset trading platform, the UK CATP, or CATP operators are required to apply. And the first requirement is that CATP operators must establish a criteria to assess whether the admission to trading of a qualifying crypto asset on the platform is likely to be detrimental to the interests of retail investors. So they have to establish this criteria before admitting a crypto asset to trading. The criteria must be risk-based and objective, and it must take into account the fitness and propriety of identified persons, such as the person requesting the admission and others that are responsible for the offer. The quality of any QCDD or supplementary disclosure document produced, the ability of those responsible for a QCDD supplement to pay compensation under the crypto asset regulations, the resilience, technical functionality, and credibility of the crypto assets governance and operational arrangements, any known risks associated with the underlying technology, whether it is possible to verify information related to these persons or matters, and finally, where information cannot be verified, how this would affect retail investors' interests. So before admitting a crypto asset to the CATP operator has to have an admission criteria. It's part of the due diligence before admitting the crypto asset to trading. The CATP's admission criteria relating to fitness and propriety are expected to take into account any contravention by persons of some of the other rules contained in the crypto asset, the new crypto source book. And CATP operators must ensure that their admission criteria is approved by their governing body, so the board. It must be regularly reviewed and updated as appropriate by the governing body, and it must be published on the website of the CATP. CATP operators must apply their admission criteria consistently when assessing if admission to a qualifying crypto asset to their platform is likely to be detrimental to the interests of retail investors. And as part of the due diligence processes in this initial admission stage, before it is admitted to trading, before the crypto asset is admitted to trading by the CATP, operators must implement measures to mitigate the risks of applying their admission criteria less rigorously or objectively when first assessing the admission to trading of a qualifying crypto asset on their own behalf, or where the request for admission comes from a member of the same group as the CATP operator. So additional measures to mitigate conflicts of interest where the crypto asset is being admitted by the CATP itself or by a company in the same corporate group as the CATP. So for example, a subsidiary or something. And CATP operators are expected to, at a minimum, have written policies that ensure separation between the areas of the business responsible for commercial decisions relating to the admission to trading of the qualifying crypto asset and those responsible for conducting the admission assessment, and that individuals responsible for commercial decisions regarding the admission are not responsible for carrying out the admission assessment. 1 second, I'm just going to get my dog. I'll introduce you to my dog. Oops. Okay, great. This is Mercutio, and he's going to join us because I have to supervise him. Okay, so further in terms of the due diligence processes, there has to be an assessment of potential detriment to retail investors. So before a CAT-P operator can admit the qualifying crypto asset to trading on the platform, they have to assess, with reference to their admission criteria, whether admitting the crypto asset is likely to be detrimental to the interests of retail investors. And this assessment is required for the admission to trading of all crypto assets or qualifying crypto assets on the CAT-P, including those that are admitted on another UK CAT-P. And indeed, if the CAT-P operator carries out their assessment and they consider that its admission to trading is not in the interests of retail investors or it's otherwise detrimental, then they must not proceed with admitting the crypto asset to trading. And then within a reasonable time before publishing any QCDD, qualifying crypto asset disclosure document, in connection with the admission to trading, the CAT-P operator must, 1, produce a report summarizing any information relating to the persons or matters mentioned in crypto, a bunch of rules, which we'll explore later, and that the CAT-P operator was unable to verify when carrying out that assessment and provide the report to the person requesting the admission if that person is not the CAT-P operator. So remember, when we were discussing the admission criteria, the CAT-P operator has to establish who is responsible for the crypto asset or who is requesting for it to be admitted to trading. So if you can't establish who those people are, you have to mention that in your report, that you are unable to verify them. And then guidance also provides that when the CAT-P operator, when they're preparing their rule book, requiring they must include a rule in their rule book requiring QCDDs to state what information could not be verified during that initial assessment. So you carry out your due diligence procedures, and then the information that could not be verified during the assessment must be the subject of a report. Apologies, I also have a second dog who's currently barking. Production of QCDDs. So a CAT-P operator must include a rule in its rule book requiring a person requesting the admission to trading of a crypto asset on the CAT-P prior to admission. So they have to provide the QCDD, so the qualifying crypto asset disclosure document for the particular crypto asset for assessment, so the CAT-P operator can assess it, and a supplementary disclosure document for the crypto asset for assessment by the CAT-P operator if new significant factors arise or there are mistakes or inaccuracies in the CDD after its publication but before admission, provided the matter may be material to a person considering buying or subscribing to the crypto asset. So if there's like a big change, you don't have to produce a new QCDD, you write a supplementary disclosure document, like a codicil kind of thing. What else can I say? When a CAT-P operator is admitting a qualifying crypto asset to trading on their own behalf, it must draft its own and produce its own QCDD document for assessment. It must produce a supplementary disclosure document if that is required, if there's been some kind of change that must be disclosed. It must ensure that the QCDD and any supplementary disclosure document complies with the rules in the CAT-P's rule book. And it must clearly state in the QCDD that the CAT-P is admitting the crypto asset to trading on its own behalf and has produced the relevant document. Oh, good. So a CAT-P prior to admitting a crypto asset to trading on the platform, they also have to carry out checks. So a CAT-P operator must not publish a QCDD or any supplementary document unless they are reasonably satisfied, having carried out an assessment, that the QCDD and any supplementary disclosure documents together include the information required by the statute. So there are these new regulations, the crypto regulations, and these are the ones that empower the FCA to make more granular rules in the FCA handbook. But so Regulation 13 sets out the information that has to be included in the QCDD. And we'll go into that in a bit. And the information in the QCDD and any supplementary disclosure documents is true and not misleading, or if reasonable efforts have been made but information could not be verified, and this is adequately disclosed in the QCDD. And then finally, the CAT-P operator also has to be satisfied that the QCDD and any supplementary disclosure document complies with the rules in the CAT-P's rulebook. And if it is produced by the operator themselves, the equivalent requirements as they would apply to any other person requesting admission, they have applied to themselves. It's expected that the CAT-P operator will carry out this assessment for all QCDDs and supplementary disclosure documents before admitting qualifying crypto assets to their platform and allowing them to be traded, including documents previously assessed for the same crypto asset admitted to trading on a different CAT-P. So even if the crypto asset is admitted to trade on a different CAT-P, the current CAT-P prior to admitting the crypto asset to trading must carry out an assessment and review of the QCDD anyway. It doesn't vitiate the due diligence requirements imposed on the CAT-P if the qualifying crypto asset is already admitted to trading on another CAT-P. Where a CAT-P operator is unable to verify information in a QCDD for assessment purposes, they must first produce a report summarizing the information they were unable to verify. And if the QCDD was produced by a person other than the CAT-P operator, provide the report to that person. And then in the guide, this is guidance. The FCA give guidance that a rule must be included in the CAT-P's rule book requiring QCDDs to state what information was unable to be verified, and reference should be made to the impact of unverifiable information on the interests of retail investors. That's so interesting. So even though the consumer duty doesn't apply to admissions to the A&D regime under FSMA, it still has real consumer duty elements. You know, we're constantly hearing this phrase, interests of retail investors. I mean, that kind of sounds like the needs, characteristics, and objectives of the retail customer, I think. Similar. All right, what information is required to be in the QCDD? Excuse me. Okay, so this is the information that is required from the crypto asset regulations. So this is kind of unwavering because it's in regulations. So first, you have to include information material to a person considering buying or subscribing to the crypto asset, enabling them to make an informed assessment of, first, the features of the qualifying crypto asset, the risk associated with holding the qualifying crypto asset. There's some things about stablecoins, matters relating to the parties who are requesting admission, any issues relating to the control of the crypto asset that could impact its price or value, and any underlying assets. The required information in the QCDD document may vary upon the nature and the circumstances of the persons requesting admission, the type of qualifying crypto asset, and whether the crypto asset has already been admitted to trading on a qualifying trading platform. Minimum expectations. So the regulations set out exactly what must be in the QCDD, and then the FCA rules kind of elaborate on these and give minimum expectations as to what should be included or how to interpret the regulations. So minimum expectations from the FCA as to what should be included in the QCDD to comply with the regulations include a description of the governance mechanisms affecting the qualifying crypto asset, explanation of the characteristics and usage methods of the crypto asset, details regarding the operational and cyber resilience of the underlying technology, information on protocols, industry standards, and any planned updates or changes, discussion of the technological vulnerabilities and mitigation plans, disclosure of technology audits and vulnerability mitigation measures, ownership details, including concentration and any lockups options, past trading performance of the qualifying crypto asset, and major events or tech changes influencing the crypto asset or its ecosystem. So the the crypto asset regulations, the regulations that we've been talking about, are the Financial Services and Markets Act 2000, FISMA 2000, Crypto Asset Regulations 2025. And the relevant section is Regulation 13, which is general requirements to be met by qualifying crypto asset disclosure document or supplementary disclosure document. So here, I'll share my screen just quickly in case this is of use. So this is the requirements from Regulation 13. So there's A, B, C, D, E, F with some subsections. So the rights and obligations attached to the qualifying crypto asset, all these. This is what's required by statute. This is the guidance provided by the FCA. So this is their interpretation of the minimum requirements. That's what is required to meet this. And then if you put them together, these kind of map. So I've kind of mapped the guidance to the statutory requirements. So they kind of line up, they kind of don't. It's probably best that it's not too prescriptive. And then a CATP operator has to perform checks on the QCDD, and they have to assess whether the information in the QCDD is true and not misleading. So they have to verify the identity of persons referred to in the documents using public records or other checks, so some kind of KYC type situation. Information on utility, rights, governance, or technical features of the qualifying crypto asset should be assessed for consistency with its underlying code, documentation, or observed behavior on chain. Disclosures on token supply, distribution, and lockup arrangements in the documents should be checked and supported by on-chain data, and information relating to development progress or partnerships should be credible and supported by evidence. The documents must include appropriate disclosures of material risks and limitations associated with the qualifying crypto asset And the CAT-P operator should look for omissions or inconsistencies in the documents when compared with publicly available information on the crypto asset or similar assets. Okay, so we've carried out our due diligence, we've got our criteria, we've assessed it, we've carried out our checks. Now, can we please finally publish our QCDD? So a CAT-P operator may not admit a qualifying crypto asset to the crypto trading platform unless they publish any required QCDD on the website, and then they upload this onto one of the national storage mechanisms. The CAT-P operator must not publish a QCDD unless it's carried out all of these checks that we've discussed over the past 10 minutes. When uploading a QCDD or supplementary disclosure document to the national storage mechanism, the CAT-P operator must have a legal entity identifier with an issued registration status on the GLEIF, okay, Global LEI Index. So this is just some kind of operational requirements to upload the QCDD to the national storage mechanism. A CAT-P operator must publish and maintain on their website a list of QCDDs and any supplementary disclosure documents they have published which relate to the qualifying crypto assets currently admitted to trading on any UK CAT-P they operate. There are some exceptions. I don't really want to go into them in detail, but I will mention them quickly now. So this doesn't apply to admission of a qualifying crypto asset on a UK CAT-P. If it is a qualifying stablecoin, there are separate rules for qualifying stablecoins. The qualifying crypto asset is fungible with a qualifying crypto asset currently being admitted to trading on the same UK CAT-P, or a QCDD was published in connection with the earlier admission, and a QCDD was published in connection with the earlier admission. So if it's fungible with a crypto asset that's already admitted on the platform, so there would already be a QCDD in respect of that earlier admission. Only qualified investors will be able to trade in the qualifying crypto asset if admitted to trading. So if trading this particular crypto asset is restricted to qualifying investors, not just any retail investors, then this section doesn't apply. If this section does not apply, the CAT-P operator may still include rules in the platform's rule book requiring documents similar to the QCDD or supplementary disclosure document to be produced, and then publish these. Okay, so how must the QCDD be presented? So QCDD, so we note that the A and D regime is not subject to the consumer duty. So we don't have any elements of the cross-cutting rules or the outcomes, particularly consumer understanding would be relevant here in terms of the general presentation of information in a QCDD. So how must it be presented? If it was, generally speaking, any other customer-facing document produced by a firm, Part 4A firm or an EMI/PI firm, it would have to comply with the customer understanding outcome under the consumer duty. But the A&D regime under FSMA does not, the consumer duty doesn't apply to it. So how should this, so absent the consumer duty, how should QCDDs be presented to retail investors? Okay, so QCDDs and supplementary documents should be in English. They must meet retail investors' information needs, be understandable, enable informed decisions, and communicate clearly and fairly. Protected, forward-looking statements must be clearly marked. Guidance suggests presenting information logically, using plain language, highlighting key info, and providing appropriate detail to aid decision making. Signposting. I mean, this sounds very customer understanding. What else? Documents must include the name and the legal entity identifier of the person requesting admission, any digital token identifier, a statement of responsibility, withdrawal rights, and information about potential supplementary documents. There's some additional information that's required in a QCDD if there is a potential conflict of interest. So a QCDD must clearly disclose any financial interests in the qualifying crypto asset held by certain individuals and entities. And these include the CAPI operator, any group members, directors or senior managers, and any controllers of the operator, of the CAPI. And then if the CATP operator can't verify particular information that must be included in the CATP, then they have to kind of flag this. So the CATP operator must include in its rule book a provision which mandates that any QCDD produced by virtue of the relevant rules must contain a clear and prominent statement of any information the CATP operator was unable to verify. This applies when the operator has produced a report specifying such unverifiable information either as part of its assessment of admission criteria or prior to the publication of the QCDD. In short, the rule ensures that any limitations in verification are transparently disclosed within the QCDD or supplementary disclosure documents, highlighting to investors any areas where the CADP operator could not confirm the provided info. So flagging any info that you can't verify independently. Okay, so a CATP operator must also include a rule in its rule book requiring that every QCDD contains a summary of key information. So you've got the QCDD, but then you also have to produce this kind of summary thing at the start. Say hello. Hello. Okay. So the summary must serve as an introduction to the QCDD. It must present the key features and risks of the qualifying crypto asset to help retail investors consider whether to invest. It must be true and not misleading. It must be consistent with the other parts of the QCDD. It must be written in plain English. It may not be longer than 2 pages of printed A4 paper. It must include a warning not to rely solely on the summary for investment decisions, but also to consult the full QCDD. It must include a warning that neither the summary nor the other parts of the QCDD will be updated if a supplementary disclosure document is published, and it must include a clear and prominent reference to statements in the QCDD regarding possible supplementary disclosure documents, conflicts of interest, or non-UK qualifying stablecoin status if relevant. The CATP operator should ensure that this summary the summary has to include at a minimum the name and digital token identifier of the qualifying crypto asset, the name of the persons who produced the qualifying crypto asset disclosure document, cross-references to locations within the QCDD where further info on matters mentioned in the summary can be found, and clear and prominent references to statements about supplementary disclosure documents, conflict, blah, 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 blah. Not exciting. Almost there. All right, withdrawal rights. Yes, how exciting. This is conduct of business. So exciting. Withdrawal is possible. So if you've subscribed to a crypto asset and you wish to withdraw, so Withdrawal is possible if the agreement was made after the QCDD was published and a supplementary disclosure document is later issued before the crypto asset is admitted to trading. The withdrawal must occur within 2 working days of the supplementary document's publication, unless an extension is granted. The supplementary document must clearly state the right of withdrawal, the time frame, and contact details for exercising this right. If crypto assets are bought directly from the offeror, they must inform buyers about potential supplementary documents and withdrawal rights. Intermediaries must also inform buyers about supplementary documents, assist with withdrawal rights, and notify them on the day a supplementary document is published. Responsibility for QCDDs. So there are provisions in the FCA rules on responsibility for QCDDs and supplementary disclosure documents. And these provisions are intended for individuals who have participated in the preparation of a QCDD or supplementary disclosure documents. It sets out who bears responsibility for these documents under the crypto asset regulations. And anyone deemed responsible may be liable to pay compensation in accordance with Regulation 14 of the crypto asset regulations. So the persons responsible for a QCDD or a supplementary disclosure document include the person who requested the admission to trading of the relevant crypto asset if the document was produced in connection with such a request. The operator of the CATP operator if they produce the document in connection with admission to trading of their own platform. Any person who accepts responsibility for the document and is explicitly stated in the document as doing so. Providing advice about the contents of the QCDD or supplementary disclosure document in a professional capacity alone does not make someone responsible for the document. And these don't apply to qualifying stablecoins. Maybe we can do another session on stablecoins. Okay, and then finally, protected forward-looking statements, just going over these really quickly, high level. So these rules focus on the use of forward-looking statements in QCDDs and supplementary documents. Forward-looking statements must be clearly identified and accompanied by cautionary language explaining that actual results may differ. The rules provide guidance on how to present these statements to ensure they are not misleading. There are specific requirements for disclaimers and the context in which these statements are made. And the aim is to ensure transparency and protect investors by clarifying the speculative nature of certain projections or forecasts. Thank you very much for tuning into this podcast. I hope to see you at another podcast in the future, hopefully on crypto assets. Thanks, everyone.